Good evening and welcome. You're watching Breaking Views, a show where we get you all the views so that you get the complete picture. I'm Sanket Upadhyay. Now, Gyanvapi, the mosque issue, has become a controversial issue. A survey has been ordered. That survey itself has become quite controversial. The survey commissioners who should be submitting this report, who should be kicked out of the survey, all of that is a subject matter of discourse. Meanwhile, the matter has reached the Supreme Court also. In terms of legality, where does the Gyanvapi case stand? Can it be challenged? You see, there is one provision in the law called Places of Worship Act. Now even that is being questioned. So then we ask a question, is Gyanvapi going the Ayodhya way? And today, for the purposes of this broadcast, we are going to restrict ourselves only to a legal argument in this case. I would like to welcome a very senior panel of lawyers on this show who can put perspective on what they feel is correct. Top lawyers will debate on NDTV. Arema Sundaram is a senior lawyer of the Supreme Court. Nalin Kohli, senior advocate of the Supreme Court. Good to have you, Mr. Kohli, on the show. Tanveer Ahmed Mir, another senior advocate of the Supreme Court. In just a short moment, we'll also have Mr. KTS Tulsi. He's also a senior advocate in the Supreme Court. This is an important from a legal framework, a very, very important discussion. Mr. Kohli, I want to begin with you. You know that there is a Places of Worship Act 1991, which very clearly states that apart from Ayodhya, the religious structure of or the constitution of any place shall remain the way it is starting 15th August 1947. Do you feel that all the legal arguments are basically not keeping in mind the fact that this law is in force, upheld by the Supreme Court in the Ayodhya judgment?
No, I think, Sanket, we need to step back for a minute. We need to understand that essentially everything is emanating from a proceeding in a trial court in Varanasi, which essentially was a suit for declaration in terms of seeking the right to pray and do darshan and other things, which is filed way back in 1991. It is that suit which has resulted in the first commissioner being appointed, a survey being conducted, and that's the matter of challenge that's read before the Honorable Supreme Court. Now, essentially, to immediately jump on to say the 1991 Act, this is obviously going to be an argument of those who have invoked the jurisdiction of the Honorable Supreme Court, and I think my colleague Mir will probably expound on that. On the other hand, there is going to be a set of arguments that are going to come with regard to if a shivling has been found there, what should be done. In terms of Section 4 of the same Places of Worship Act that you are referring to, the 1991 Act, which clearly says, that, certain sort of structures would be excluded. Section 4.2 is clearly there. Additionally, there will be arguments in terms of, the order itself, which has been said that, how was an injunction passed? But that also is pretty strong in terms of a 39(1)(2) under the Civil Procedure Code. Anyone can take an ex parte injunction if they feel that there is a need for it. And that application led to the cordoning off of the area, which also has been recognized and protected by the order of Justice Chandrachud and Justice Narasimha just a day ago. Of course, the rights of the namaz to continue in the structure has also not been impeded in any way. So we have to wait for all of it. These are all the questions that will come up before the Honorable Court. But and I have no doubt that there will be forceful arguments both sides.
One more point that I want to ask you is that don't you think that the manner in which this flip-flop is happening on the issue of the advocate commissioners in Varanasi, right? He was removed by the court. Today, there is another petition in the very same court which will be heard tomorrow on whether he should be brought back. In the meanwhile, a report that he managed, in his supervision, that report was written, that survey report. He was kicked out of that report. That very same report will be presented also in the court tomorrow. Do you feel a report where there have been so many flip-flops will be acceptable? Should it be acceptable?
No, I don't think a report. There are 3 or 4 parts that we need to look at it, and you are having a rather eminent panel here. Many of my senior colleagues are there. I think the fact of the matter is, let's first step back. All these arguments may have merit one way or the other. At the end of the day, it's for the court to decide. Now, there will be, in any suit, there will be minimum 2 parties. There may be additionally a large number of parties as interveners or as parties. They are all going to put out their arguments. Court will look at the entirety of it and pass an order. Now, each issue should be segregated. The question of whether the commissioner acted appropriately or not is one thing to be decided. The second is, how correct is the survey? That's the second part of it. The survey and the report is known to the court. It has to be placed before everyone to know the facts and the content. But then there is an aspect of how have things got leaked out. The videos doing on the social media, doing rounds on the social media or even on the channels are certainly not. They seem to be older videos of the Wuza Khana being cleaned much before the survey took place. So I think there are multiple things that are happening here. We should allow the court proceedings to look at each one of these aspects rather than mix them all together and then arrive create a confusing situation
since
and
this is a discussion
possibly the
purely
viewer.
from a legal point of view, you're saying that it should not be mixed all together. The point is, a bunch of these petitions are being filed together, thus leading us to conclude, at least politically, an argument. Let me go introduce Mr. Tulsi. Mr. Tulsi, do you feel that it is a coincidence that so many petitions have been filed, not just in the Gyanvapi case? You look at Taj Mahal, Mathura, various other cases also. Do you think it is in the Supreme Court also, that this is just a coincidence? And thus, my question, do you think Gyanvapi is going the Ayodhya way?
Well, it's the court is trying its level best to get.
Okay, we're going to fix that video connection on Mr. Tulsi. But Arema Sundaram, would you like to respond? What, according to you, is, let's talk about the legality, Mr. Sundaram, of say, a Places of Worship Act.
Look, let's be very clear about one thing. The matter is today before the Supreme Court, and the Supreme Court is deciding to hear this case. So I don't think it lies in any of us to discuss of matters which are directly an issue before the Supreme Court. Also talk about the effect of the Act. As Nalin just pointed out, both sides will have some. But we have to understand what the issue really is from. That stems from a basic social-religious issue. Whether we accept it or not, with the Ayodhya case and the way the Ayodhya case, the doors have been opened for claims for religious protection on the one hand, and on the other for saying, restore to us religious sites which we once had. These are conflicting claims which will arise. The 1991 Act in that context wanted to bring about a situation where this did not happen, being aware that India as a country has been conquered time and again by different forces, by different rulers, different religions. And therefore, there's a lot of changes in the topography.
But Mr.
So
Sundaram,
because of that, the Act came in. Please allow me to answer. Please allow me to answer. Your question is very specific. Do you think this will go the Ayodhya way? My answer is, I am not an astrologer, but I can tell you that after Ayodhya, the doors have been opened for similar arguments to come out with regard to places of religious worship. Tomorrow, it could be birthplace of Krishna. It could be other issues. But after Ayodhya, I think it is one thing is clear, that the Supreme Court has to that extent recognized that these kind of basic religious claims have to be looked at and protected and sorted out. And to that extent, I'm sure that the 1991 Act, so long as it stands, appears to be clear to a person like me, may be amended, may be watered down, may be looked at differently. But if that Act is to be taken as it stands, it appears to say that Ayodhya is the one and only exception, there's nothing else. Now, socially, religiously, I don't think that is practically possible.
While you say that is practically not possible, Mr. Sundaram,
other doors
in the Ayodhya judgment itself, the Supreme Court very clearly mentioned, it referred, I clearly remember reading the word retrogression, that we should not
I fully
indulge
agree
in...
with you. I fully agree with you. But your question was different. You think that all these matters will start going the Ayodhya way. Whether they actually go or don't actually go is a different issue. But will there be an attempt to make them go an Ayodhya way? The answer is yes, because you have to understand the socio-religious reality of India. Most people in India are extremely religious and ritualistic and believe in a lot of things which have to do with deities who have been on the Hindu firmament, for example, or on the Islamic.
Okay, let me ask this question of Mr.
So
Tulsi.
this you will have repeatedly, and after Ayodhya, you will have that door being knocked at repeatedly.
So, Mr. Tulsi, R.M.A. Sundaram feels that Ayodhya in a way paved the way for these arguments to take place. That, people are deeply religious and then they will have a natural expectation that if Ayodhya happened, then this should happen too. Is it just people's expectation?
Yes, I agree with him.
Yeah. Mr. Tulsi.
I agree with him. You see, the court is trying to get at the truth at the moment. So they are trying to get the best evidence, and the best evidence is the walls of the mosque. If those walls show shivling, it will be quite clear that it was demolished. The temple was demolished to construct a masjid. Now, if that is the situation, the status quo ante will have to be restored normally. That is what happens. In this case is much more serious than the Ayodhya. Ayodhya, there was complete lack of proof, but here it is possible because the historians have identified that it was mosque was constructed by Akbar by orders of the Akbar, and then there are other set of people who say that it was Aurangzeb. Now, even if you leave history, the Supreme Court or the court trying the suit has directed that a video recording will be done of the process of studying whatever is there on the walls of the mosque or the temple. So once that's a first-hand evidence which was not possible and wasn't available in the case of Ayodhya. But I think that people have a right to continue to pray at the place if the temple was indeed pulled down to create a mosque. We should deprive crores of people to pray to their God. And in any case, if at all this has been done by the Mughal emperors, there is nothing wrong with reversing it. Okay. At least for the future.
Okay, but then the whole point on retrogression. I want to introduce Mr. Mir also, Tanveer Ahmed Mir. Then how far back in history do you go to correct a historical wrong? From a legal point of view, how do you address this conundrum, Mr. Mir?
Sanket, this question has already been answered by the Constitutional Bench judgment, the judges of the Supreme Court in Ayodhya, where it was said that, when the 1991 Act was also put to the test, so their lordships then said that, look here, the history is replete with so many examples of conquerors, kings, annexing kingdoms and then, going after places of religious significance, demolishing them, constructing, demolishing. This has been but what has been in the language of the judges, which is a part of the judgment, is that enactment of the Constitution was a watershed development in India. Once the Constitution is enacted, you have a principle of rule of law, and then you have the 1991 Act. The 1991 Act only gives an exception for Ayodhya. Now, my understanding is that till this act is in force and it is not amended, scrapped by the legislature, any suit which is directly in conflict with the covenants of this act, the final relief can never be granted. Let me tell you, the Constitutional Bench judgment said that when it comes to 1991 Act, the enactment of Constitution and recognition of secularism as a basic structure doctrine in India, constitutionally mandates the government and the court for equal treatment of all people, in fact, their religious symbols as well. That's why the objective of the act was whatever religious structures are there, whether it's a temple, whether it's a mosque, whether it's a church, as it existed in 1947, it shall not be diluted, it shall not be changed. That was the objective, that is what was debated in the parliament, and that is why the law was enacted. This law
No, but then, Mr. Mir, I'm sure you heard Mr. Sundaram's argument also that in a country like ours,
Yes.
where the society in a way thought that their doors of redressal are open post the judgment, post Ayodhya judgment. How
I
do you
don't think
respond?
so.
I understand this
How
legal
do
point
you
that
say?
you're making.
The question is, sir,
But
the
now there is
laws
conversation of reviewing Places of Worship Act also.
See, the point is that either the 1991 Act can be challenged in two ways. For example, one lawyer, Mr. Upadhyay, has filed a petition in Supreme Court last year on which a notice has been issued.
Yeah, Ashwini Upadhyay.
Unless and until the Honorable Supreme Court does not declare the 1991 Act as null and void or ultra vires the Constitution of India and especially the Bill of Rights, which we call as Part 3, or alternatively, the Parliament of India as it stands today, and there is now noise that we are going to revisit the 1991 Act once this survey comes into play. Let me tell you, in a title suit, survey is nothing. You know, it's one side against another side, one claim, counterclaim. There's something called as a survey. Some expert has to come in a suit, and Mr. Aryama Sundaram himself is one of the legendary lawyers in civil law. He knows it very well. So is Mr. Tulsi. In a civil court, in a claim, if you basing your claim on a particular assertion, you have to authenticate it, which means that survey is not an evidence. Point is, after the survey, in a civil suit, some expert has to come. Some expert has to come. He has to testify. That expert has to be then cross-examined by the other party.
Okay.
Question is whether the Supreme Court now is going to allow the suit to continue if the final relief cannot be granted. I fail to
Nalin
understand
Kohli, how would you respond?
How the suit is continuing.
Mr. Kohli's response, please. Okay, we'll just try going back to Mr. Aryama Sundaram. You heard what Mr. Mir had to say. Would you like to respond?
Well, I wouldn't like to respond as to how the Supreme Court is going to react because that is a matter which is sub judice and I certainly will not.
Correct.
But I go back to what I started from. We are in a country which has religious tolerance as a part of our constitution. We are a country which guarantees freedom of religion as a fundamental right. We are also in a country which has people, and more than most other countries, the Indian is very religiously bent, is very philosophically bent, and religion and rituals for an Indian are very intrinsic to the large majority of the population. And if they feel that a place has a religious significance to them, which they can really empathize with, they will want to go and visit that particular location, that particular shrine, that particular site to offer their prayers. And that is the mentality of a religious person. That's why I said it's socio-religious. And to tell this person that, look, it was only for Ayodhya, and the Supreme Court happened to say that they will not apply this anywhere else, will not stop the person from trying to knock at the doors and say, allow me also the right to worship in the spot because it's a sacred spot for me. Will not stop him from trying to knock at the doors and say, look, I know it has been done before in Ayodhya. Why can it not be done here? That person cannot be told, look, here, this constitution bench says this or does not say this.
I agree, you can't second
So
guess
I'm
the
on a
court.
practical
Nobody
issue here. I'm not
From a
on
legal point of view, how is this?
I feel it's sub judice.
How is this possible? Can it even be done given the fact that we've got this law in place? Nalin Kohli, I want to come back to you. Mr. Mir, just a short while ago, he said, he again reiterated that provision of that law. You said that there are certain exceptions in that law also. Now, Ayodhya being one. Are you saying that there is now a case being built to review this law?
See, let's leave this law out for a moment. Let's go back to some legal fundamentals. End of the day, an act or a statute is but a creation of the legislative process. So there would be a law for the centre or for the whole country which would be passed by parliament or by a state legislature for a state. Those laws can be amended, they can be repealed, they can be removed, and this happens. There are 1500 archaic laws that the government has removed from the statutes. They were not required. The constitution itself has undergone change also. The first amendment was in 1951. But what can't change is the basic structure of the constitution, and within that is the power of judicial review. So now two things emerge from these principles. The first, any individual organization can invoke the majesty of the constitutional courts, raise a question of importance to them in terms of their fundamental rights or otherwise, go there and wait for the court to look at the arguments on all sides and pass a judgment. Judgments change with time also. You may have a 3-judge bench overruled by a 5-judge bench, maybe a constitution bench of 7 or 9. So this is a constant process which is part of rule of law. It has nothing to do with one act or the other act. And that principle will apply. So for someone to stand up today and say everything is cast in stone, I'm sorry to say, nothing is cast in stone except a few fundamental things like the Fundamental Rights, Chapter 3, the power of judicial
then
review,
in that case,
things like
Mr.
that.
Kohli, Mr.
Everything
Mir wants
else,
to come
courts
in.
will decide, and we must bow down to the courts.
Tanveer Ahmed Mir wants to come in. Mr. Mir, then again, the basic question is how far back in time? Tomorrow, a deeply religious person of a different community.
I just want to 1 minute, Sanket.
Will want to go back 500
years. It's an important point. When the matter is before the court, we have to have the patience to wait for the court to say anything on this. And I think I agree with what Mr. Sundaram has been consistently saying.
Okay.
Tanveer Ahmed Mir. What I see is that Honorable Mr. Justice Dhananjay Chandrachud was a part of the 5 judges bench in the Ayodhya one. Now, the Honorable Chief, upon mentioning, referred the matter to their lordships. Lordships are sitting in 2 judges bench. If 5 judges bench have already delivered a verdict on 1991 Act, then the option available to 2 judges is to escalate the matter to at least 5 plus 2, 7 judges, or 9 judges straight away. Now, if that is not done, I as a lawyer and my fellow panelists are far more senior lawyers than I am. The problem here is, can 2 judges overrule a 5 judges verdict? If they cannot, what they can certainly do is they can order and then request that this aspect of Ayodhya judgment, in terms of authoritatively endorsing the 1991 Act, needs to be having a look again, and therefore we request for a 7 judges bench, and that the 7 judges bench can then deliberate and hear. Now, 2 judges cannot overrule 5 judges by any stretch of imagination. When the Honorable one of the judges
Mr. Kohli's response,
the earlier judges.
Mr. Kohli's response, and then Mr. Tulsi.
Alternatively, as my friend Mr. Nalin said, otherwise the option is available for the Parliament. Now, the longer question is here, that are we catapulting our country into some kind of absolute phase where tomorrow some Buddhist will say that, look here, I had a stupa which was there existing 2000 years ago, and that was demolished and a temple was constructed on the top of that.
Okay, Nalin Kohli. Nalin Kohli, I think the point that Mr. Mir is saying, that how far is this cycle going to go? Because everybody will claim. I mean, I agree with Mr. Sundaram. Obviously, there is a sentiment in the people that if it has happened in Ayodhya, then a deeply religious person who has certain beliefs will expect it elsewhere as well. Where does the law come in here? How would you respond to what Mr. Mir is saying?
Mr. Sundaram has consistently also said we should not second judge a court, and that's the point I'd strongly again add to. End of the day, judges don't have the liberty of sitting on panels. They are eminent, learned people. And when a matter or a list is before them, we have to allow them to apply their judicial mind. They are trained, they are responsible people, and therefore we must have that faith. That's one part. So what they are the options before them, what they should do, what they should not do, at least I'm going to restrict myself from saying so, because that's how the judicial process is.
Okay.
I have a right to argue my case. The opposing counsel has a full right to argue their case. And that's exactly what Mr. Mir is doing, arguing his perspective as someone who's on the other side has the full right to argue the counter arguments. Secondly, is an argument is taken beyond, say, law, in terms of how far back we go or this.
Yeah.
There's another aspect that needs to be considered. Justice is a wider concept than just mere rule of law. So if there has been at the seed of something gross injustice or a wrong has been committed, can you say that eventually that should be discarded? So these are complex questions in jurisprudence, and we need to wait. They are not black and white questions.
Okay.
And that's why when it's before the highest court of the land, we have to bow down to it and wait to see what happens in the proceedings.
Absolutely. Absolutely. We have to do that. Thank you very much, gentlemen. Arema Sundaram, Nalin Kohli, Tanveer Ahmed Mir, as well as KTS Tulsi for joining us on this discussion. With that, it's a wrap in this edition of Breaking Views. News continues on the other side. Stay with us.